with your technology. It could be on our end, I don't know. But so we apologize to you as well. With that, unless there's some objection, I'm going to propose that we just proceed, although we don't have the benefit and the pleasure of seeing ADA King.
I don't have any objections.
I don't.
Okay, by you, Attorney McKenna?
No, Your Honor.
And
My background's
my
now.
panel on board with that? All right, then why don't we do that? This case is 19P 1785, Commonwealth versus TYEMIKE Smith, I believe is how you pronounce his first name. My name is Justice Desmond, and with me is Justice Ditkoff and Justice Singh. Will be your panel for this morning. And notwithstanding a couple of the technological glitches we've experienced, we're going to try to keep these hearings as normal as possible. And we just appreciate your patience. If we run into, or if you run into any technological issues in the course of the hearing, kindly let us know in any way you can, and we'll try to address it in the moment. We have some staff who's ready, able, and willing to assist us in that endeavor. That being said, Attorney McKenna.
Good morning. If it pleases the court, Gail McKenna, and I represent Ty Smith in this appeal from his convictions, his firearm convictions. In this case, we've raised 4 issues, and I'd like to, I think, address 2 of them on the appeal. I think they're all sufficiently briefed, but I'd like to start by talking about the stop here and the fact that in this case, the Commonwealth failed to justify this presumptively unreasonable stop and seizure of a vehicle that Mr. Smith was a passenger in. The officers in Worcester stopped the car because in the view of one of them, he thought he recognized the driver. And he also believed, based on months old information, that the driver's registration was, not the registration, his license was expired. So he just turned his cruiser around and pulled the car over. And
so isn't that enough? If you believe that, he believed that he saw a person known to him who is not properly licensed driving a motor vehicle. If you believe that, isn't that enough for him to make a stop?
No, Your Honor. That's nothing more than a random stop that's at the discretion of police officers. It's not reasonable because there's no objective standard here as a measure. It's no more than the kind of stop in Delaware versus Prowse that the Supreme Court said simply wasn't adequate for those reasons. Anybody at any time could say, hey, I know that guy, turn the car around and stop them. And in fact, here, the officer readily admitted that he could have made a mistake here. And that type of reasoning would lead to everybody being stopped all the time. It's just simply boundless discretion on the part of police officers.
Yeah, that if someone doesn't recognize me driving as someone that they have heard has a suspended license, they can't stop me. Why does it allow anyone to be stopped at any time?
But well, the second problem, and this is a 2-pronged problem, it's the failure to actually know who you're stopping, which is problem number 1. And it's the stale information about the driver's license. The officer readily admitted that the driver's license information was months old. And
it's reasonable suspicion. Isn't that the standard?
Well, you know, but it's not reasonable. It's not reasonable when a tip is, 2 or more months old. I mean, that's just presumptively stale because you can change, he could have gone in that morning and renewed it. It's a very simple thing for the police officer just to run the individual's driving record and find out that it's activated or not activated. But even beyond that, you can't just stop people.
Are you saying that that's what the officer was required to do in this instance? If he believed that he knew this individual and that the individual's license was suspended, are you saying that under these circumstances, before he stopped, and he was required to run his license?
Absolutely. Absolutely. I mean, 10 minutes earlier, he could have been at the registry fixing that situation.
What's your best case for that?
Delaware versus Prowse, the United States Supreme Court case. And I would also rely on this court's jurisprudence too.
What's the best mass case you got?
I think that I cited Washington, perhaps. There's so many cases, and one of the problems that I think we all have with some of these stop cases is that every single one is fact dependent. I can't, I'm sorry, I'm having trouble hearing you, Judge.
You mentioned the circumstance that you can get your license reinstated online within minutes. So what is a reasonable time frame? Let's say the information was an hour old. In the circumstance where you can renew your license or you can reinstitute it within minutes, is an hour-old information stale? I'm trying to figure out the contours. You're saying information that's a month old is stale.
Right, and 1 to 2 months is absolutely stale. But I would also say that, where every police car has a computer in it, it's a very simple thing to run the information before you do the stop. They could have simply followed him while they were running the information, but then they still couldn't have stopped him because they didn't really know who it was. And under Delaware versus Prowse, all that means is you're stopping everybody because you think you recognize them. It's standardless, which makes it unreasonable. And unreasonable searches are the very thing that the Fourth Amendment in Article 14 prohibited. We just can't have that type of society where people are stopped based on the fact that an officer or someone else might just happen to recognize them. I mean, as I said, even the officers.
Well, it's beyond that. It's beyond simple recognition of the person. It's recognition of him while knowing that he's not licensed to operate on the streets of Massachusetts. And so with that in mind, doesn't he have an obligation to stop him? If he believes that he sees a crime being committed in his presence, doesn't he have a duty to stop him?
I would say no, Your Honor. I would say in this circumstance, it was, he didn't have a reasonable belief that this individual was committing a crime or had committed a crime. It wasn't reasonable at all because he did nothing to confirm that belief.
In the end, it was confirmed when he asked the defendant Smith, and he told him he didn't have a license. Is that right?
Well, I think if we have the idea that all searches are fine as long as we find something, then we've undercut completely the Constitution. Not to be fresh at all, Your Honor, but we can't say a search is okay because it's all's well that ends well because we found something. I mean, you just can't do this type of investigation. And I think a case that's really good on this is one that was cited by the Commonwealth. I think it's Commonwealth versus Baez. And that's the only case where the SJC has said it's okay to kind of stop for an investigation. And that had to do with tinted windows. And it said under Chapter 90, Section 90D, that particular automobile violation, you could stop the person for that. But what the trooper did in that case is he drove up beside, he took a second look, he made sure that it was dark, he had specialized training, and he had a meter with him so he could quickly check it and let the person go on their way. But there's no other reasonable way to check for that particular violation. And Baez said that this is a very limited in scope ability to stop to do an investigation. If you're stopping people to investigate their identities, those are random stops and the very thing that our Constitution prohibits.
So if you have to confirm prior to the stop that his license is suspended, then what role does reasonable suspicion play?
Well, here it doesn't because you don't have any. It's not reasonable to believe that you might have recognized someone or you might not have recognized someone. That happens every day. What these officers needed to do was maybe follow the car until he got out, get a good look at him. In the meantime, all they have to do is run his license information. Pretty simple steps. Well, the other thing that every other officer in Massachusetts does is they wait for him to take a turn and not use the blinker. Pull him right over. But that's not what happened here. What happened here was just a randomized stop.
Why is
I'm
it
sorry.
better if they wait till he gets out? Why are they able to recognize him when he's out of the car, but they can't recognize him when he's in the car?
He asked him who he was when he stepped out of the car.
What
So,
about- so until he says who he is, they can't stop him?
no. My point was, because the officer said, I only got a passing glance. And our judge's findings here are that he had to confirm the identity and confirm the license status once he pulled him over and got him out of the car. That perhaps he could have followed him, gotten a good look at him and said, yeah, that's him. But we don't have that here because it's not what happened. Here we have the judge's findings reflecting what the officer testified to, which was that he had to confirm all of that. He didn't know that when he pulled them over, and it doesn't come within the very strict, limited strictures of that Baez case that we talked about just a minute or two ago.
Where in the findings does it say that he had to confirm the identity before he knew it was Cunningham?
Hold on a second. Reading glasses. He says, I think it's on the second page, halfway down. I apologize for fumbling here. I thought I had it tabbed.
And it says he did confirm it, but I don't see
Sorry?
if he had to confirm it to know that. It says he did confirm it, but it doesn't say that he had to confirm it.
Well, Your Honor, I read that as saying he did confirm it. All the testimony is that he had to confirm it. And the Commonwealth is not contesting that it had to be confirmed. He would have to he'd have to make a finding against all of the evidence in order to find that he knew who it was, because there was no evidence that he knew who it was.
So on page 8 of the transcript, I recognize the operator to be an individual who was a local gang member, and the individual's name, Kashim Cunningham. Why can't the judge credit that?
Well, because he didn't. He said he had to confirm it,
Well,
or he
didn't
did
say-
confirm it. If someone's confirming something, at least in my mind, it means that they don't know it.
Let's say, for the example, that and this may be a little far afield, but let's say that the driver had a gun in his hand in the car when he went past the officer. Would the officer have a duty to say, hey, I think I recognize Cunningham, and check with the firearms licensing board to determine that he didn't have a license to carry the firearm before he stopped him?
No, because if someone's waving a gun around, I think that's a much different circumstance. And I gave that as an example, in fact, in my brief, of one circumstance where it might be appropriate to stop someone. You know, had they gotten a radio call about shots being fired, a gun being waved, something along those lines, create a different kind of objective situation that should result possibly in a stop. But here, you know, the only reason the SJC has repeatedly affirmed the authorization doctrine, which says that if it's something objective, and they recently did this in LaRose, a bright line test, fog line, is because it's objective. And things that are objective are reasonable. Things that aren't objective, like, you know, I think I recognize someone, and there is more testimony there. And I would say that I think that the language confirmed does comport with all of the testimony, including the officer's testimony that he might have been mistaken. I think as long as there is no bright line test, it's unreasonable. And unreasonable searches violate the Fourth Amendment, as this one did, I would assert. I mean, he was stopped for no other reason than someone thought he recognized him and thought that his license was invalid. Two things that were unreasonable under the Fourth Amendment.
Noting the time, let's get to your client.
My points, I think, in addition to this, are that the exit order there was no reason for the exit order. He was just sitting there minding his own business. There was no sense of any danger. He was compliant with everything that the police wanted to do. He wasn't nervous. The judge said that he was an active gang member. One officer said incorrectly that he had an active gun case and the driver fled, and that was the reason to make Ty get out of the car.
I don't know why you say that was inaccurate, because he did have an active case and it was a gun case. The gun wasn't operable, but it was still a gun case.
It wasn't his gun. It wasn't found with him. It was somebody else in the car.
Well, why does that matter? As long as they have reasonable suspicion there's a gun in the car, what does it matter whose gun it is?
I think it does matter.
You've got to remove him.
I think it does matter. I think that, and I think that there's a case on this point too, at the SJC that says just having a gun isn't enough. I think I cite that in my sufficiency section of the brief. But, you know, lots of people have things in cars, and I don't think that as a matter of the Constitution that we want to be stuck with everything that somebody else has in a car at any given time. There's no proof that he had any knowledge of that gun. None at all.
That's a trial issue.
No, but I think it's also.
Why are you arresting a gang member and you have real suspicion that there's a gun in the car? You can't order the passengers out while you.
What is that reasonable suspicion that there's a gun in the car?
But if there is, you're saying the exit order was invalid. Are you saying it's because there was no reasonable suspicion of a gun?
Well, there's no reasonable suspicion that my client did anything wrong. I mean,
why it matters that your client did anything wrong. If they have real suspicion there's a gun there, no matter whose it is, why don't they have the right to get everyone out of the car while they deal with that dangerous situation?
well, you know, in our cases, what has happened is that the SJC has routinely said, small steps, you can go one by one. Unless it's something like the case in Commonwealth versus Elise, which is really an explosive situation where everyone was ordered out of the car because it was in the middle of a gang fight. I think that the Commonwealth requires a measured approach. Now, there was no reason to order him out of the car. He hadn't done anything wrong. He was just sitting there minding his own business, and there was no reason to believe that there was a gun in the car. They stopped for a suspended license, and the other person ran away. He could have run. That was the testimony. He just sat there and he did everything that the officers asked him to do. And yet he was ordered out of the car. He wasn't handcuffed. He stood by. He could have run. He chose not to.
What is a reasonable inference to the police that Cunningham ran?
Well, I think the police themselves said he ran because of the license. So,
well, how could they know that?
You know, that's a good question. How could they know that? How did they know it wasn't Cunningham's gun? But you know, we have to say that you know, until they investigate, what do they know? Nothing at all. There's no inference that you can draw to Ty because the other guy ran.
They know that they have two at least one known gang member driving in a gang area that's not their own, not their home turf, that one of them has a suspended license and ran when they stopped. So they know all that. You agree?
Well, you know, I disagree on one point though. Ty's near his home where he lives. I mean, he's on his way home.
Well,
so,
they didn't know Ty initially. They knew Cunningham was a known gang member in an area that's not his home turf with another man in the car who's not licensed. It's, I think, 6 o'clock in June or something, and ran when they stopped him. It wasn't until after they got a good look at Mr. Smith that they determined that, oh, he's also a Kilby gang guy also.
Well,
So,
you know, I'm sorry to interrupt, Your Honor.
No, that's all right. I'm sorry.
Well, I think, you know, when we apply the Cruz factors, one of them is that you have to look at the person's own criminality, not the co-defendant's alleged criminality, in determining whether or not there's a reason with this probable cause or a reason to order somebody out of the car. Cruz says the passenger's crime must be something separate. He didn't do anything. I mean, he did nothing. In mere status of being a gang member, you know, I don't really know from this record what the gang status had to do with anything.
I get it. I get it. I get that. And I'm gonna ask your sister about that too. But that aside, they knew that Smith had the pending gun case. They may not have known whether it was a joint venture gun case, whether the gun was in his hand. They knew that Smith, Kilby gang guy, had a pending gun case. Cunningham, Kilby gang guy, was driving unlicensed in a adversarial turf, for lack of a better word, my term, not theirs, and ran. That's not enough for some heightened.
Your Honor, my time's expired. May I answer?
You may.
Thank you. I would say no, because you can't just pile inference upon inference to get to probable cause. A series of zeros still equals zero. The gang stuff doesn't add up to much because we have nothing in the record showing why that matters. It's very much unlike the case that I cited to you, Commonwealth versus Elise, where the record is chock full of information about the adverse gangs and what's going on and why a particular stop mattered, and why police had to act the way that they did. As far as you know, the other person running, we have Cruz that says, well, you can't depend on this other person's criminality. That's a pretty basic value of American jurisprudence. You're only guilty for what you did, not from the people around you. And I would reiterate, and I disagree with the court, that someone else's gun case should taint you for the rest of your life and allow someone to get you out of your car for the rest of your life when there's nothing that attached you to that gun. And had they run his record right then and there, and they could have, they would have seen that there was no gun charge against him, because there wasn't. So unless there's any other questions, I'd respectfully rest on my brief. And thank you all for your kind attention today.
Thank you. ADA King, what do you say?
I say good morning, and may it please the court, your honors. Michelle
Good
King,
morning.
Assistant District Attorney for the Commonwealth. The motion judge properly denied the motion to suppress, and this court should affirm that decision. With regard to the stop, your honor, the information that Officer Roberge had in his testimony at the motion to suppress was that he recognized the operator of the vehicle. He recognized the operator, and he recognized that he was a member of a local gang. He also testified that he knew that the operator was not licensed to operate a motor vehicle within the Commonwealth. Based on that information, your honor, he pulled the driver over for a proper motor vehicle stop. And two cases I would point this court to that support the fact that this was a proper motor vehicle stop. The first one, your honors, is Commonwealth v. Washington. And in that case, in footnote 14, the court said, an officer's reasonable suspicion of a possible but unconfirmed motor vehicle violation sufficiently justifies an investigatory stop in order to verify or dispel that suspicion. And I would suggest, your honor, that that's precisely what happened here. Although Officer Roberge believed that the driver did not have a motor vehicle, a right to a valid license to operate in the Commonwealth, he was permitted to stop the vehicle in order to confirm the information that he had.
So if that's true, what difference does it make that he's a Kilby gang guy? It seems like in the government's brief, every other sentence is alerting me that, hey, he was a gang guy, he was a gang guy, he was a gang guy. The passenger was a gang guy. Does it matter that he was a gang guy? If you see somebody that you believed, that you recognized, and he's driving a motor vehicle with what you believe is a suspended license, what difference does it make if he's in a gang or not?
Perhaps not for the stop of the vehicle, Your Honor. The stop of the vehicle was wholly justified by the fact that Officer Roberge believed that, recognized the driver as Mr. Cunningham and believed that he did not have a valid license. Where the information with regard to gang membership, I would suggest, comes more into play was the exit order. And I'll get to that in just one moment. If I could just back up 1 minute and talk a little bit about confirmation with regard to knowledge of the driver, with your court's permission. I'm happy to answer your question now,
You
but
certainly may.
I thank you. With regard to specific knowledge and whether or not you have to have knowledge that the operator of the vehicle is who you say or who you think it is for a valid license, if this court looks to Commonwealth v. Garden, in that case, the officers believed that the owner of the vehicle had a suspended license. Based on that information, they pulled the vehicle over, not knowing whether or not the owner was in fact the operator. And in fact, once they pulled the vehicle over, the owner was not the operator. The owner of the vehicle was a female and the operator of the vehicle was a male. And the Supreme Judicial Court said that before the officers stopped the Honda, they knew the owner had a suspended license. Because they did not know at the time that the driver of the car was a man, this license information provided a reasonable suspicion to believe the registered owner of the vehicle was driving with a suspended license. So in that case, they had much less confirmation in terms of knowledge who was driving the vehicle. They only knew in that case that the registered owner did not have a valid license. Here, Officer Roberge testified that he knew it was Mr. Cunningham and he believed that he was driving without a valid license. So I would suggest to you, based on Washington and Garden, there was more than enough information to make a valid motor vehicle stop of the car that Mr. Cunningham was driving. With regard to the exit order and Your Honor's question about gang membership, I believe that's where I would suggest to the court that that's where gang membership of both of the occupants of the vehicle comes into play. With regard to the factors that the motion judge considered when determining that the exit order for the defendant was valid, the motion judge considered the fact that both occupants of the vehicle were gang members. He considered that Officer Smith had knowledge that the defendant was involved with a prior gun case in a car. And he also cited the flight of the driver as a factor when considering whether or not there was, again, enough information to warrant the defendant to be ordered from the car for safety concerns.
Did the officers testify that they ordered him out of the car for safety concerns? Or are we supposed to infer that because the officer waited for another officer to come to the scene? But when I was looking over that, I wasn't sure that the officer said that. I know the judge found that, but did the officer say that?
That is a good question, Your Honor. Let me see if I can point to it very quickly. In the meanwhile, I know that the motion judge certainly made that finding. And there is certainly a reasonable inference that based on Officer Smith's knowledge that the defendant had a prior gun case involving a car, that's a reasonable inference that there was a safety concern. I'm trying to look to see if there was actual testimony of that, and I don't have that information, Your Honor. I can certainly look for that in his testimony and write a post-argument letter, but I don't recall that specific testimony. But again, I believe that the inference is that he was ordered from the vehicle for his safety because he knew that the defendant had a prior charge for a gun, again, involving a car, and that he was a gang member, and that the driver of the car had fled. And so those three factors, if you look at, certainly any one of those factors alone may not be enough to tip the scale. But when you look at the totality of the circumstances, as this court should, there are a number of cases that take each of those individual factors and say they're valid factors. For example, if you look at Commonwealth v. Elise, that this court said that gang membership alone is not enough, but the police are not required to blind themselves to gang membership or circumstances in which they find themselves with gang members. Commonwealth v. Torres says that the flight of a passenger, any one of the passengers in a vehicle, is a factor. Again, not a determining factor, but certainly a factor. And Commonwealth v. Amato, the Supreme Judicial Court said that the officer's knowledge of the defendant's recent arrest for a gun offense was a factor that could be considered when determining whether or not an exit order was valid. So again, each of those factors individually may not be enough, but in this case, we have three solid factors that gave Officer Powers enough concern about his safety to order the defendant from the car. And that is a fairly reasonably low standard, Your Honor, a low bar when determining whether or not there's enough to order someone out of the vehicle, especially for safety concerns. So I would suggest to you that the exit order of the defendant, in this case, based on the totality of the circumstances, was sufficient. With regard to—
Hold on, Judge Singh. Hold on 1 second, please. Judge Singh?
Yes. What in your brief you say that that the officers were justified and that this was part of a threshold inquiry. What was being investigated at that point? What do you say was still being investigated at that point?
Have we moved on to the search aspect of it, Your Honor? Is that, I think I talked about the threshold inquiry as part of an alternate argument that I made with regard to the search.
Right.
Yes, okay. Correct. So, well, at this point, we have the driver who has fled, and we have a passenger who, again, looking at all three of those, well, at least two of the factors, the officer knew that he had a prior gun offense involving a vehicle and that he was a gang member. And so as under a Terry threshold inquiry, he is allowed to search the interior of the vehicle for safety concerns. And so in this circumstance, defendant says, well, he's no longer a concern because he was out of the car, and that really what the police officers should have done at this point was call the owner of the vehicle and have that owner drive off. But if they don't do an inquiry in terms of a threshold inquiry for a gun or the safety concerns inside the car, the defendant could have been allowed to get back into the car and drive away. And so under Terry, the Officer Powers was allowed to make a protective sweep inside that vehicle to search for weapons based on the fact that that defendant had a prior gun offense involving a car and he was a gang member.
But didn't they ask him whether he had a license before that? And he said he didn't.
Correct, but that doesn't mean that he couldn't get back.
To drive away in that car, right?
He could not be the driver of that car, but he could be a passenger in that car. The defendant suggests that they should have simply called up the owner and the owner of that car and allowed that person to come and drive away with the vehicle, in which
Right,
case the defendant.
They weren't necessarily under any obligation to do that. I mean, depending on
Correct.
where they stopped the car and what the road conditions were, they could have opted to determine that there wasn't any licensed driver available and towed the car and done an inventory search, or left the car on the side of the road if it wasn't in a dangerous place that it might be robbed or what have you. They had other options other than calling the owner. Is that fair to say?
That is fair to say, Your Honor. They absolutely could have done any of those options, but none of them are foreclosed. And so they could have conceivably allowed someone else to drive it. They could have had it towed, or they could have just left it there. Correct. But one of the options was to call the owner and have that person drive off, in which case the passenger could have driven off with that person with a gun under the seat. And so that possibility left open a reasonable choice by Officer Powers to do a protective sweep within that car. And at that time, the defendant was not handcuffed. He was simply just standing outside of the vehicle.
So do you believe that the exit order turns on the fact that he had either a pending gun case or the officers were aware of the gun case? Do you think it turns on that?
I don't think it turns on any three of the factors that I mentioned. I think that.
Well, if we take away the pending gun case or the conviction on the gun case or the gun knowledge, then how do they order him out of the car? On what do they order him out of the car?
It significantly weakens my case, Your Honor. If Officer Powers does not have that information that the defendant was involved with another case where there was a gun in the car. And again, it really matters not whether it was the defendant's gun in the other case, or it was the defendant's gun in this case. It's a safety concern. And so if the defendant has a propensity to drive around with people who have guns in their cars, whether or not it's actually in his possession doesn't matter in terms of safety concerns. It may matter when it comes to sufficiency, but it does not matter with regard to this officer's safety concerns.
So I recognize that that's your time, but I do want to ask you one additional question, which is this evidence about the passenger had previously handled the weapon and had wiped it down. Do we know when in time that actually happened? Didn't it seem a little misleading, as if that the passenger was suggesting that he had just wiped that gun down and he knew he had handled it, when that may have happened at some other point separate in time, maybe days? I know you say earlier that day. Is there evidence of it earlier that day?
I believe there was evidence that it was earlier that day, Your Honor,
Okay.
which is why I put it in my brief, though. And I refer to whatever citation I put. I don't know it off the top of my head, but I believe there was testimony that it was earlier that day, and the defendant admitted that he had it in his possession, that he had wiped his fingerprints from it, and that he believed that it was loaded.
Okay.
I have one question, though we're out of time. Counselor, if we determine that the firearm should have been suppressed, do we need to reach the grand jury insufficiency issues, or is this a case where you accept that it's untriable without the firearm?
Well, if the firearm is suppressed, we have no case, because both of the charges are based on possession of a firearm. And if the Commonwealth can't prove possession of the firearm, I would I would imagine that this case can't go forward.
Thank you.
Hearing no other questions from the panel, I think that's, we'll take the case as being submitted. Thank you very much.
Thank you, Your Honor.
Thank you.
We appreciate it. Very well done.
Thank you.
I'm going to bring in the attorneys for the next case right now. Are you guys ready?
We are.
Okay. Where did they all go? There they are. Travis Lynch. Peterson.
Attorney Lynch. Morning.
Good
Morning.
Can you hear us okay, Attorney Lynch?
Yes, I can hear you.
Morning, Attorney Peterson.
Good morning, Your Honor.
So good
Can you hear
morning.
us okay? Oops, I'm sorry.
Yes, I can hear you.
Okay.
All right, this is the matter docket 19P0253, Commonwealth versus Alvin Page Jr. My name is Justice Desmond, and with me is Justice Ditkoff, and Justice Singh will be your panel for this morning. We appreciate your patience with us as we move our hearings to this remote Zoom platform. It doesn't come without some technical difficulties here and there. We're trying to iron them out as best we can. So please alert us if you can't hear us or if you can't see us, if you have any issues. We do have some staff who's ready, willing, able to assist us if that should occur. We've read your briefs. We're familiar with the arguments, and so you need not recite the facts, but I leave it to you to expend your time as you see fit. Attorney Peterson.
Good morning, Your Honors. May it please the court. My name is Jennifer Peterson, and I'm here today on behalf of the defendant appellant, Mr. Alvin Page. As Your Honors know, I raised three arguments in the brief, and if I may, I'd like to start with argument number one and then move to argument number three. With respect to the first argument, did the judge err in dismissing juror number 4 while treating juror number 35 differently, both of which had to do with sleeping juror issues? I would suggest that in both instances, the judge didn't go far enough. He was on the right track with respect to questioning these jurors when he was alerted that they were asleep. With respect to the first juror, juror number 4, when he was called up to speak with the court regarding this in a voir dire, he denied sleeping. He denied sleeping at least a half dozen times and said that he was listening. He was able to recite the facts in detail. He responded well to the judge's questions.
Well, I'm going to stop you there.
Okay.
I'm going to stop you there for a moment. Because as to that point, whether or not he was able to recite the facts in detail, it seems to me that Judge Ricciardoni had some concerns with the facts that he was reciting when we really kind of got close to the bone of the government's case. In fact, it wasn't only that the judge had been alerted that this juror was potentially sleeping, but the judge himself had witnessed what he believed was the juror sleeping. And when he asked him some straightforward questions about kind of what took place after they got back to the house from the aquarium and or wherever they were for their day out and gave the birthday gifts and all of that, it seemed as though the juror wasn't really able to hone in on what the government's facts were. Would you agree or disagree with that?
I would disagree with that, Your Honor, and I would disagree because I think a lot of the judge's questions that were directed to the juror were not necessarily on point. So the judge asked the juror, what happened after the aquarium? Well, just about everything happened after the aquarium. I mean, there were a lot of different things that happened. So I think the juror went into some significant detail, but it wasn't clear. I don't necessarily, he was trying to respond. It was clear he was trying to respond to the judge's questions, but I think it was unclear where the judge.
Hold on 1 second. Judge,
what do you make then? The judge does ask one very specific question, which is, what did I say after the sidebar on page 101? And the juror can't answer that. Instead just says, I wasn't sleeping.
The juror responded, though, that there were 4 sidebars, that there are a number of sidebars, and which sidebar did he mean? So the juror was aware that there were several sidebars. And that goes to my point, Your Honor, that it's kind of unclear as to what the judge was asking. And ultimately, defense counsel requested that because the judge indicated that he found that this juror may have missed important portions of the testimony because he didn't recite details regarding the strangulations and some of the acts of violence that were testified to. However, defense counsel suggested, and I think rightly so, that you could ask in a sort of a general way, did you hear about any acts of violence? Because when you read the colloquy back and forth between the judge and the juror does respond to each of the judge's questions, but they're so open-ended. I don't necessarily think the juror could know where the judge was going, or that the judge was looking, like Judge Desmond said, to get to the closer to the bone and the important part of the testimony that the judge wanted to ensure that the juror hadn't missed.
The question that comes to my mind, however, is that the juror didn't speak to any of the violence. Of all the things that he heard, and the judge was questioning him about, did you just hear the Commonwealth's case, or what the prosecutor was asking? I don't believe that the juror touched on any of the violence. And that certainly was apparently, I won't say certainly, apparently suspicious to the judge. Did you read it that way?
Well, he made reference to the fact that she talked about it later on, that evening, but he didn't talk about the actual testimony. And I think the whole matter could have been resolved and easily if the judge would have asked one additional question. I think he asked questions, but he needed to ask the question, which is, can you recall any acts of violence that were, or something to that effect? Because he was clearly said he was taking notes. He denied sleeping at least a half dozen times. And there would be, go ahead.
Sorry. Didn't the juror also allude to, well, I have a little one at home?
I believe that may have been the case at some point, but I don't necessarily that would neither.
I was just curious, what value, why would he say that?
Perhaps because he's tired. I don't know, Your Honor, but I don't necessarily think it doesn't mean he's not paying attention, or that he's not just sitting and listening with his eyes closed. It was a very stuffy courtroom from the reading of the transcript. And it seemed as if a lot of the jurors were struggling to stay awake. I think that's a fair reading of the transcript. And this in particular, he said he was taking notes. So had he been given the opportunity, the judge could have clarified this very simply and very quickly had he just asked one additional question. The defense objected to the dismissal of this juror. And the judge could have asked the question to ascertain if he missed the bulk of the Commonwealth's case in chief. And the juxtaposition with how the judge treated juror 35, I mean, juror 4 repeatedly denied falling asleep. Juror 35 readily admitted that he had been sleeping. And in
Are
juror
you suggesting that as a matter of law, the judge had an obligation to treat both those jurors the same?
I would think that, the judge has an obligation to engage in prompt judicial intervention. I think that, when they were talking about juror number 4, both counsel, both the DA and the defense counsel, both indicated to the judge that they believed he was originally talking about juror 35. And they indicated to the judge that they had seen juror 35 sleeping the previous day, as well as sleeping during opening statements. At that point, the judge was alerted.
Counselor, I didn't see any place, maybe I missed it, where the defendant asked that juror 35 be excused.
I don't believe defense counsel asked that he be excused. He indicated that he had, I think that it's the judge's obligation to promptly intervene if there is a sleeping juror. That I think both counsel addressed the issue when the issue with juror number 4 came up. And then when juror number 35 came for a voir dire at the end of the day before the weekend on Friday afternoon, the judge, when he spoke to him, the juror specifically admitted that he had been sleeping. The juror said, and he had to be called back because the counsel pointed out the fact that he was sleeping previously. And he said, as far as he knew, he caught the opening statements when he was asked about that. Any kind of prior days issues weren't even addressed by the judge or by anybody. Now, he didn't object.
Hold on. Judge,
Okay.
Once the judge has done all that, doesn't the defendant have a duty to either ask the judge to do more or to ask that the juror be excused?
I would suggest that anytime there's a sleeping juror and anytime there's a possibility that a juror has slept through any kind of significant portion of a trial, McGee tells us that it's structural error. And so it can never be considered harmless.
Closed courtroom is a structural error, and if a defendant doesn't object to it, it's not an issue. So that doesn't answer that question.
I would suggest, though, that the defendant did object to his not being dismissed, and he didn't object per se, but when the judge asked him whether or not he thought he missed anything important, he said, well, I hope it was important. So in essence, he was saying, yes, I think he did, because, juror number 4 missed part of the Commonwealth's case. Juror 35, who was retained, missed the part of the cross-examination of the alleged victim.
now you indicated that, so 2 points. One, you indicated that if the court determined that the juror missed some significant portion of the testimony, and that the judge had a duty when it was brought to his attention, or whether he caught it himself, there was a potentially sleeping juror, to act promptly. You're not suggesting that the judge didn't act promptly in either of these instances, are you?
Yes, I'm suggesting the judge should have gone a step further.
But that's different than acting promptly. So I wanted first, are you suggesting that the judge did not act promptly?
To the extent that the judge didn't go far enough, I don't think he acted properly, because I don't think he completed his job. I think he began by acting properly. I think speaking to these jurors was proper. I think that when he, I think he allowed juror number 4 to continue to sleep. That's how the record reads, before actually calling him up, or if he thought he was sleeping, juror 4 says he wasn't, then he should have, ensured that this juror was awake. He also, I believe, acted improperly in not addressing counsel. Counsel is a reliable, source of information. And if both counsel said juror number 35 was sleeping yesterday, he was sleeping during openings, and they both thought, when the judge was talking about a potentially sleeping juror, that he was referencing juror 35. So I would think it would be incumbent upon the judge at that juncture to look into that issue and to hold a voir dire, not just with juror 4, but with juror 35 as well.
So I may have misunderstood what you said, because I was saying promptly and you were saying properly.
Oh, yes. Sorry, Your Honor.
So I apologize. Judge Singh.
Counsel, in juxtaposing the way
I'm having a hard time hearing you, Justice.
in juxtaposing the manner in which the judge dealt with the 2 different jurors, the African-American juror and the non-African-American juror, I suppose, not really identified. are you raising an issue of judicial bias? Is that really what you're putting in front of us?
I don't think the record necessarily supports an issue of judicial bias. However, I think the optics are there. And I think that justice requires not only justice, but people need to feel as if justice is done. And when you're African American is a defendant and the sole African American juror is being dismissed, and the white juror, I mean, you can't help but juxtapose the way the judge treated these two different allegedly sleeping jurors. And one seems to be treated as if he's credible. Oh, you slept, it's not a big deal, we'll worry about that later. The other one seems to be, okay, we don't believe you, we don't believe what you're saying, we don't believe when you say, you know, you weren't sleeping, you're dismissed. So you can't help but notice the difference in the way these jurors were treated.
And the judge noticed the difference, and he spoke to that difference on the record, didn't he? The judge recognized and found it unfortunate that he happened to be the lone African American juror, but determined that the race wasn't going to trump his duty, which was to make sure that the defendant was getting a fair trial.
Well, I think the record speaks for itself, and you know, that's the nature of bias. It sometimes, you know, can look one way and be another, and it can sometimes be one way and look another. So the record is what it is, and I think the record speaks for itself. And if I may, though, I'd like to move on to my third argument, because I notice I'm running out of time. The failure to give the specific unanimity instruction, even the district attorney, even the ADA could not speak to which incident Mr. Paige was supposedly engaged in to support the assault and battery that he was convicted of. Even at sentencing, he specifically said, well, we don't know that. He said the defense would say that Mr. Paige was convicted of a push, but we don't know that. There was no kind of coherent, there were a number of different assaultive episodes that were testified to, from hair pulling to pushing to 2 attempted strangulations, a number of different things. And the prosecutor in the opening and closing didn't address it. And there was nothing about that said this is a separate and distinct act. This is the act that constitutes the assault and battery. And if you look at the Palermo case that's cited in our brief.
Hold on one second. I'm going to interrupt you for one moment, please. Justice Singh?
Cases that talk about an entire episode where there may be assaults involved, and that it's okay to look at it as an entire episode.
I would disagree that this is an entire episode. It was charged as separate incidents. So, you know, it wasn't like the government charged 2 different instances of strangulation. The government charged an assault and battery on a household member. These aren't lesser included offenses. They charged separate incidences. So for them to now turn around and say, oh, well, it was just one continuous, you know, assaultive episode, well, then they should have charged one assaultive episode. They charged a number of things. The jury found this not credible on everything but this one particular case. And it's unclear, was it the hair pull? Was it the basement push? Was it one of the strangulations? What was the assaultive behavior that Mr. Paige was convicted of? And even at sentencing, the ADA said, we don't know. We don't know. So if they don't know, how can we say with any semblance of assurance that the jurors agreed unanimously on which assaultive incident that they all believed that Mr. Paige was guilty of engaging in? And because we can't say that, Palermo says that the lack of clarity as to which incident that he was convicted of constitutes a substantial risk of miscarriage of justice. And for that reason, I believe that Mr. Paige's conviction should be overturned, as well as the other reasons cited in my brief.
Thank you very much.
Thank you, Your Honors.
Attorney Lynch. So what do you say? Were these acts close enough in time that they didn't need to be distinguished by virtue of a specific unanimity instruction.
Good morning. I mean, it did take place all of the assaults took place in the same location on the same night against the same victim. And I mean, it's sort of like Thatcher, and cases like it where I think just as Justice Singh pointed out, it's one episode, it's one continuous course of conduct. And what's very decisive about the specific unanimity instruction issue here is that the defendant did not request the instruction. And when you look to, cases like COMMONWEALTH, for example, in COMMONWEALTH, it was multiple acts on diverse dates, and the defendant did not request the instruction. And failure to request the instruction, it's very difficult, I would suggest, for the defendant to succeed on a unpreserved specific unanimity instruction issue. And the Palermo case that the defendant cites, the crime that was at issue there was threatening, and the defendant threatened two different people in quite different ways. He threatened one person with a knife, and then he threatened to sexually assault the victim's mother. So in that case, the threatened conduct, the crime, was very different. So here, as I said, it's like Thatcher and cases like that, where it's overall one course of conduct. Have I addressed your question?
In part.
Okay. All right, well.
Why don't you address your sister's first point and speak to whether or not the two jurors were treated so disparate that there was some error?
Well, I don't see, that's a sort of novel issue. I've never seen a case where there's two different jurors and where the claim is that the error consists in the differential treatment, but it seems to come down here to the judge's credibility determination. He credited the first juror. I apologize. He discredited juror number 4 and he credited juror number 35. And that's an unreviewable credibility call by the trial judge. And he was really in the best position to make that call. And the judge states on the record during one of the sidebars, and the prosecutor says, he's sleeping right now. The judge states on the record, I see him sleeping. That is juror number 4. And as to juror number 35, as to the part of the cross-examination that juror 35 might have slept through, you can see I put it in footnote 8 in my brief. That seems to be the portion of the cross-examination that he might have missed. And as you can see, it's just not that important. In sleeping juror cases, the Commonwealth gets into a great deal of trouble where the judge fails to create an adequate record to determine what, if anything, the allegedly sleeping juror might have missed. Like in Villalobos, where the court said it's complete speculation on the Commonwealth's part to assert. So here, I think it's pretty clear what, if anything, juror number 35 missed. And so the way that the judge handled juror number 35, I don't think that's an abuse of discretion given the page or maybe page and a half, I think, of transcript that's missed. And that cross-examination is based upon a text message that was in evidence. So it's really not that important. And the judge also gave the defense attorney the opportunity to re-ask questions on cross-examination on Monday, on the next day of trial, if he wished. And the defense attorney said, or agreed to that, and did not take the judge up on his offer. So that, I think, suggests from the defense perspective that particular set of cross-examination questions were not actually that important. And also the appellate court, this panel is in an excellent position, unlike in Villalobos and Braun and so forth, to actually see what the juror might have missed. And I would just submit it's not very important. So, but I think to really hone in on the disparate treatment argument, I think that the defense counsel has said that the record does not actually support a finding of judicial bias, and I don't think that a direct appeal on the cold record like this is really the right way to raise that claim. I don't think that that's really before the court. And as I said, the difference in treatment comes down to the judge's credibility determination. And as I think Justice Desmond pointed out, the judge even says, he essentially says, I don't want to remove this juror. It's a real shame that I have to, because we all want to see a diverse jury. But this juror was sleeping. And as the court said in Lawton, given the judge's finding that the juror had slept through an important portion of the testimony, he had to remove him. So that would be my response to the defense argument on the disparate treatment of the two jurors in this case.
Anything additional you'd like to share with us, Attorney Lynch?
No, unless the panel has any other specific questions, I'm content to rest on my brief.
Hearing none, the matter stands submitted. Thank you both. Very well done.
Thank you.
So you guys want to keep going? You want to take 5? How's everybody feel?
I'd like 5.
Okay. Can you hear us? Okay, I can't
I
see.
can hear
Oh,
you.
there you are.
Okay, we are now live.
Okay. Good morning, still morning. Good morning to you both, Attorney Gallagher and Attorney Macero. Thank you kindly for your patience. Transitioning to this remote platform does have some challenges. So we appreciate your patience as we try to iron out any technological glitches that we may encounter on the course of the hearing. Please let us know if for some reason you can't see or if you can't hear us. We'll try to address that promptly and sufficiently. My name is Justice Desmond. With me is Justice Ditkoff and Justice Singh. We'll be your panel for this morning. We've read your papers, and so please feel free to get right to the heart of your argument. You need not recite the facts unless you find them pertinent to your argument. That being said, Attorney Macero.
Good morning, and may it please the court. Anthony Macero from Jones Day on behalf of the defendant appellant SP. This appeal stems from a decision of the Norfolk Probate and Family Court, which denied SP's counterclaim seeking a deviation from the durational limits under the Alimony Reform Act. The issue at the core of this appeal is whether SP, a permanently and totally disabled victim of severe domestic violence, was afforded full and fair consideration of whether the interests of justice required a deviation in her case. She was not afforded such consideration. Based on a misapplication of issue preclusion, the court erroneously prevented SP from fully presenting information related to her health and to the effects of RN's abuse on her well-being and earning capacity. These were both statutory factors the court was required to consider in its analysis.
Let me ask you this question, Attorney Macero. With respect to the domestic violence point that you raised, and the fact that it's your position that she was foreclosed from offering evidence, kind of connecting the violence to her diagnosis of, pronounce it for me.
Syringomyelia, Your Honor.
Thank you. Did she have an expert witness?
Not at this time, Your Honor, but there were medical records she attempted to offer, but it's also not disputed and found previously that the nature of her disability is post-traumatic syringomyelia. So the cause of the disability is a trauma. And she also asserted in her pretrial memorandum, and could have testified to the same effect, that she suffered no accidents between 1988, when the strangulation event occurred, in 1993, when she had her first surgery associated with this disability. And she could have also testified to other effects on her health after the traumatic event, based on her own personal knowledge of those facts, Ron.
Walk me through where the judge said that she couldn't do that because of res judicata. You cited Appendix 3, page 144 to 145. And while the judge clearly won't let her testify that he caused the disability, I don't see where he says you can't testify about disability at all.
Well, the judge didn't specifically say that, Your Honor, but the effect of the court's ruling on that issue was that SP was foreclosed from testifying, and she was not able to reassert the issue in the course of the proceedings, which were generally tipped against SP from offering her case in any event.
I don't understand that. If a judge says, I'm not going to take testimony that he caused her disability, why does that keep her from testifying? All right, but let me tell you about the disability, regardless of who caused it.
Well, Your Honor, she may have been able to if she had tried to, but I think the effect of the judge's ruling on an unrepresented person in the case was that it foreclosed her from testifying to those facts. And we knew that she had evidence in the record or had submitted a document, a victim impact statement, that described the other consequences of the abuse, and it is also addressed in her pretrial memorandum. So even if the testimony wasn't introduced, it was still improper for the court to not consider the assertions that were otherwise in the record before the court when she had asserted facts and put in the record facts related to other consequences of the abuse that she had suffered.
So let me ask you, how would the fact that if she was able to prove that he had caused this disability, extended disability, how would that have impacted the ultimate determination of whether this is extended or not and for what duration? How do you see that playing out?
Well, Your Honor, whether RN caused the abuse and her ability to prove that point is central to the court's analysis of whether, in the interests of justice, a deviation would have been appropriate in these circumstances. The statutory factor in Section 53E specifically requires the court to consider whether the payor caused the payee's disability. Whether there is a disability and an inability to provide for oneself is covered by other statutory factors. So in order for this statutory factor—
when your client isn't entitled to alimony, even without the limits, because she can't show her need, and what does it matter whether a deviation would be warranted where she isn't entitled to alimony at all?
Well, Your Honor, the court committed a number of legal and factual errors in assessing SP's need and RN's ability. But getting back to how this issue affects the interest of justice determination, in order for it to—
Let's not get back there. Let's start with that, because the judge found that she deliberately lied about what her assets were and what her income was, and therefore she did not show that she had a need. So it seems to me you gotta win that before you get to deviation. So what was wrong with that?
Well, Your Honor, I think the threshold question is the deviation, but I appreciate your point, and I think the court's determination as to RN and SP's financial circumstances demonstrates an abuse of discretion and factual errors. And one particular example, I think, is particularly significant. And that is the court discredited SP's entire financial statement, in large part relying on the omission of contributions from her son on the financial statement, from her own child. At the same time, RN testified at trial that his spouse receives Social Security income. And yet, RN's financial statement does not reflect contributions from his spouse. Yet,
I don't see how that works, because husband's lying too doesn't make wife's financial statement true. She's got to show need.
But Your Honor, it does demonstrate— I'm sorry, Your Honor?
That goes to showing ability, but you've got to show need. You got to have alimony.
But Your Honor, it does reflect an arbitrary and unequal analysis of the facts, because the same deficiency was used to discredit SP's financial statement, but the same deficiency, which exists in the record, did not affect the credibility of RN's financial statement and demonstrating his ability to pay. And so
didn't SP also not fail to mention or distance herself from some of her other assets that the judge found suspicious?
Your Honor, the court did find that SP did not list assets from a trust as well. But what's significant about the omission of the court's interpretation of the omission regarding the trust assets and the omission regarding the son's contributions is that the court still makes no factual findings whatsoever about what impact the trust assets or the son's contributions could or should have had on her financial statements. The court needed to make detailed factual findings regarding what the financial circumstances of SP are. It's not sufficient for the court to state that it discredits the entirety of SP's financial statement while making no determination as to what her financial circumstances are.
How can she make that when your client is deliberately giving her misleading information, which is what he found, what she found, I mean? How is the judge supposed to do that when the parties in front of them won't give them accurate information?
Well, Your Honor, it's often done, and as was the case in the 2011 trial, it's often done by discrediting the amount that is asserted and inserting in place of that an amount that the judge believes based on the evidence that was offered. And that would allow the court to assess whether the financial circumstances of the party at the time in the here and now warranted a deviation from the durational limits. And because the court did not make those specific factual findings in this case, the court cannot meaningfully evaluate what her actual financial need was. And one point that I do want to go back to that responds to both your question and Justice Singh's question is that in order for the requirement that the court consider whether the abuse caused the disability to have effect, it must be the case that based on that factor, the court could determine that alimony is appropriate in circumstances in which it might not otherwise be. Meaning that even if the court would not impose alimony on parties who were married for the same amount of time and divorced for the same amount of time and find themselves in financially similar circumstances, the legislature specifically requires the court to consider whether the abuser's culpability for the payee's inability to provide for him or herself nonetheless warrants, in the interests of justice, a deviation from the durational limits. And that standard simply makes sense. The court has to look at what is right and what is fair in these circumstances. And when the underlying contention is that a spouse, the person who's supposed to be your partner in life, has deprived you of the ability to provide for yourself, these are exactly the circumstances in which a lengthy deviation from the durational limits could be warranted in the interests of justice.
In 2011, when she was aware of her, well, let me strike that. In 2011, was she aware of her diagnosis?
Yes, Your Honor.
And I didn't see any place in the record that she was attributing that diagnosis to the husband at that time. Did she?
In 2011, she did, Your Honor. And the credibility determination that the court made in 2011 was that it did not believe SP's testimony that RN had caused her disability.
Well, I thought you said that she didn't believe SP's testimony that he strangled her.
Well, no, Your Honor, it was that the abuse did not cause the disability. That was the factual finding of the court. The fact of the abuse has not been disputed and was admitted by RN in a Guardian ad litem report many years ago, in which he acknowledged placing his hands around SP's neck and shaking her. But that credibility determination, Your Honors, does not have preclusive effect, and the court erred in concluding that it did, because it was neither essential to the judgment or actually litigated at the 2011 trial.
And is it your position that single incident is what caused the diagnosis?
Your Honor, that was the contention in 2011, and I believe that's the contention that SP was prepared to make in 2017 as well, Your Honor. But in order to be, regardless, the credibility determination was not binding on the court in 2017 because it was not essential to the judgment or actually litigated in the 2011 lawsuit. In order to be, to have preclusive effect, the finding must be both essential and actually litigated. In 2011, critically, SP prevailed on the underlying claims. As the SJC said in Jarosz v. Palmer, and as this court applied in Hartford v. Hartford, when a finding is adversely resolved against a party who ultimately prevails on the underlying claims, issue preclusion is inapplicable by its own terms. And that is because it could not have been essential to the court's resolution of the underlying facts. Prior to the trial in 2011, RN's alimony obligation had been suspended for a number of years, I believe beginning in 2005. In 2010, SP filed a complaint for a modification seeking to reinstate alimony. Notwithstanding the court's resolution that he did not believe SP's testimony, the court reinstated alimony in the amount of $224 per week, which was the exact amount the court concluded SP needed at that time in order to maintain herself. And so clearly the credibility determination could not have impacted the court's determination of the ultimate issue, and therefore there is no preclusive effect.
Counselor, before your time runs out, your last argument is that the trial court excluded exhibits and witnesses. Where will I find those exhibits in the record?
Your Honor, those exhibits are included in Record Appendix Volume 3. I'm not exactly sure of the beginning page. I believe it's around Record Appendix Volume 2, around page 100 to 110. But I can confirm that for you as well if you'd like, Your Honor.
That's Volume 3 is all transcripts.
It's Volume 2, Your Honor, for the exhibits that were offered but excluded. I apologize.
Thank you.
And I believe they're labeled in the table of contents as proposed exhibits as well.
Wonderful. Oh, yes, I see. Yes, thank you very much.
Of course, Your Honor.
I see you have limited time left. You allude to, and almost suggest, it seems to me, that the pro se was treated differently because she was pro se. Is that the crux of your position, that she wasn't treated as a lawyer would be treated?
Well, Your Honor, I don't know if I can attribute that or would attribute that to the fact that she is pro se, but I do think the record reflects that she was treated differently. And I understand, of course, the difficulty the court faces in dealing with unequal representation in the trial proceeding. But the court's efforts in this case, I think, simply fell short, invited the opponent's counsel to testify at times, and even advised RN on specific formulations of responses to questions when he was being asked by SP. And so I think the level of intervention ultimately favored the party who was already represented by counsel and was to the detriment of SP. If Your Honors have no questions, that's my time. And for the matters, reasons stated in the brief, the judgment should be vacated and remanded. Thank you.
Thank you, sir. Attorney Gallagher.
Thank you. If I could ask, I heard everything that was said, but I had some difficulty. I had no difficulty with Judge Singh, but I had a little bit of difficulty with the other two justices, and I don't know if that can be remedied on your end. But I did hear everything. I just want to put this initially in a little bit broader context. The appellee, the plaintiff below, paid more than 12 years of alimony past the presumptive durational limit. And that amount came to about $140,000 all told. So more than 12 years past the presumptive durational limit, he paid alimony, and that was the amount in which he, the sum in which he paid. I
Is
think,
that on a 10-year marriage or 11-year marriage?
well, that was, I'm going to say that it was under a less than 10-year marriage. The court didn't deem it necessary to decide whether it was under 10 or over 10 because it was past the limit regardless. But the only judicial finding on the length of the marriage was Judge Fallon's, and he found it to be slightly less than 10 years. So whether it's slightly more than 10 years, slightly less than 10 years, I don't think it makes too much of a difference with regard to the tremendous time that he paid alimony past the limit. And I think early on in the questioning of brother counsel, it kind of hit the nail on the head, because the defendant was able to testify at trial often about her physical condition and how it affected her. That was not precluded at all. So the judge could take that into consideration. She testified, I've been permanently, totally disabled since 1995. So I think the question, I have an illness that is akin to ALS, permanent and total disability. And that's on page 120 of the transcript. And it goes on 146, 146, 155, 156, 146, 147, page 79, page 110, page 143. So she was presented with the opportunity to testify in full as to what her condition was. And
doesn't it matter?
Precluded.
What doesn't it matter what caused it?
In this particular case, I would say it's the cause does not matter. And I'm saying on the particular facts, the cause does not matter, because the alleged assault resulted in a condition that they determined was a chronic illness. And what the court did, and it's 53E1, the court considered the advanced age of the defendant, chronic illness, unusual health circumstances. And that's in her memorandum of decision. So whether the cause in this particular case doesn't affect the end result, because the cause, if it's a physical assault, is only relevant insofar as it affects the alleged victim to provide for him or herself. And that is the same consideration when you look at a person having a chronic illness for years and years and years. So my point is that E7 of the statute is, on these facts, is subsumed within E1. It would be different if the physical assault ended up with a broken arm. You'd have to go to 7 on that, because that's not a chronic illness. So those are really, they can be different, but one can be contained within the other. And I think that's what occurred here at bar.
But don't you think that we need better findings to understand that the judge did take into consideration the things that should have been taken into consideration? Do you think that we can understand what happened with the findings that we have?
I think you could, I think it's, I would say it's readily inferable for the findings of the court. She did explicitly state that one consideration was raised by the defendant was her advanced age and chronic illness. There was tremendous amount of testimony at that trial. I think you can infer that the judge took it into consideration in arriving at her conclusion. It's also clear that the court in its memorandum of decision said that it would consider all relevant law and all admissible facts at trial. It's also clear in her closing, the defendant pointed the judge to 53E and asked her to look at that. So I think based upon all these together, the memorandum of decision and the facts within it are sufficient to satisfy the result that the court arrived at here. And of course, it is the burden of the defendant to prove that a deviation would be in interest of justice. And it's difficult, as was mentioned, if the defendant provides information or financial statement that the court deems intentionally misleading. It seems that the defendant has trouble right out of the gate. How can the defendant make her point if the court determines that she's being intentionally misleading? What can the court do from there? And I would say the court is hamstrung by what the defendant did in this case. And it was clear from the transcript and the court's findings that the defendant was a co-trustee in 2 properties, 1 commercial, 1 residential. She didn't note that. And from the transcripts, it's clear that first she said yes, then she said no, and then she said she was never part of the trust, and then she said she was removed from the trust. And the court said, well, how could you be, if you were never part of the trust, how could you be removed from the trust? So the court didn't accept her testimony on that. And also the plaintiff testified that he'd spoken to one of the co-trustees 3 weeks before trial about the trust itself.
That was a brother. That was a brother. That was a brother, right?
That was a brother.
Yeah.
And that was a brother telling his sister's ex-husband that the brother saying, I can't understand why my sister, the defendant, won't agree to sell these properties. And then what happened is then the plaintiff here said, well, we're going into court a few weeks and maybe she doesn't want to put that and show it to the court. So she's holding out on that. But that still came up in the testimony. The court made its decision on that. And also it raises.
Let me ask you just one question when you talk about holding out. Do you believe that the RN's wife's Social Security income should have been included in the calculation?
It should, but he testified to it at trial. He testified. So there wasn't, you can't say, I wouldn't say that there was anything intentionally misleading about it. He testified in his direct testimony that she received Social Security monies. He didn't testify to the amount. He wasn't asked the amount. The judge didn't inquire about the amount.
Isn't the amount important or no?
Where it's Social Security, comparatively, I think it would have been a relatively modest amount. So in context of what we're all considering here, of some value, but not that it would be a turning point in any type of decision. And it was free for the defendant to say, well, what is that Social Security amount? And she didn't do that. And she has to, as a pro se, she's treated exactly the way a lawyer would be treated. No better, no worse. And what the transcript, the judge really oftentimes bent over backwards for her.
Did the judge bend over backwards with respect to the ruling regarding excluding exhibits and witnesses?
Well, I think my brother suggested that the trial judge was less than fair to the pro se litigant. But in the transcript, he does different things. She goes on a narrative, and he just interrupts and says, well, you have to ask a question, you have to ask a question, you have to ask a question. She wants to get in a document, but she doesn't know how to refresh the witness's memory. So the judge walks her through it. You've got the document, you show him the document, you point to what you want him to look at in the document, and then you ask him, does that refresh your memory? So, and he also explained the procedural matters in this case. This was the posture at this point, this was the posture later, this was the posture later. So in looking all in all, my conclusion as to how the judge treated the pro se litigant was she treated her very well, better than a lawyer would have been treated, I believe. Can I make one point on the exhibits? The court issued an order on June 27th that the exhibits and witness lists had to be exchanged by September 11th. The appellant is saying that there was an order complied with by June 26th. The relevant order is June 27th. And the appellant provides no information that anything was exchanged between June 27th and September 11th. And there's further evidence of that because the defendant provided information to the plaintiff's attorney on about September 27th. So it's clear that the plaintiff knew that she had to get information to counsel for the other side. And it's also clear that that wasn't done until weeks later.
If there's an order on June 27th that you think just means you have to give a list of exhibits, and you already did that the day before, why wouldn't you think you had complied with the order?
Well, what the court said that these things can be a moving target. So witnesses can drop off, witnesses can be added, exhibits can be dropped off, exhibits can be added. So you have a trial date of October 3rd, and to think that what you've done on June 26th will be sufficient, I would think that's not the case. But maybe it's just really much more simple than that. You know, why wouldn't this person think she had been complied with the order? Well, if she read the order on the 27th, she would have known she didn't comply with the order before that.
Now, why would she know that?
You can't ignore the second order.
But I'm sorry, what would make her think that she hadn't complied if she read the September 27th order or the June 27th order?
Because that order says what you have to do from this date forward. There's no suggestion that, oh, if you did this before, you're fine. The order explicitly says this is what you have to do. This is your end the date. Again, if she's a pro se litigant, she doesn't understand that, but an attorney would, and she's in no better position than pro se litigant.
Give the June 26th letter to the judge?
I'm sorry, Your Honor?
Did the June 26th letter that had the list of exhibits, did she give that to the judge or just the other party?
I don't know, excuse me, I don't know whether or not she gave it to the judge. I don't know.
If she didn't give it to the judge, then why wouldn't she think that she had complied with it? It wouldn't make sense that the judge was saying, oh, what you've already done isn't enough if the judge hasn't seen it.
Well, if she thought she would complied with it, but she was wrong, her thinking on whether or not she was right or wrong shouldn't control.
I mean, I suppose that also presumes that we read the language, exhibits and witness lists, to suggest we're talking about two lists versus actual exhibits and witness lists. I'm not sure what value a exhibit list is to the opposing party without the actual being able to see the actual exhibits themselves.
I don't disagree with that. It's more value to look at the exhibits than have a list, but a list by itself at least put you on notice.
I see you have 15 seconds left, Attorney Gallagher.
I've made my argument. Thank you.
Thank you both. Very well done. The matter stands submitted.
Thank you.
Okay, so mother and counsel are here. I don't know that they've spoken to each other. I asked that they have some conversation behind the scenes during that last hearing, and we'll learn right now. Thank you so much for your patience. We have run into a couple of technological glitches a bit this morning, so please bear with us if that should occur again. I think we're good right now. Can you both hear us okay?
Yes, Your Honor.
We have run into a couple of technological glitches a bit this morning, so please bear with us if that should occur again. See how I did that and I wasn't even moving my lip, okay?
What is happening?
I don't know.
Glitches a bit this morning, so please bear with us if that's
YouTube.
again.
I'm gonna
I did that and I wasn't even moving my lip.
Oh, my God. What is happening? No, no.
Glitches.
I don't know what that is.
YouTube.
So we're recording and we're streaming. Want to move forward, or do you want me to try to figure out what's happening?
Well, let's see if we get an echo. So far, so good.
Your Honor, I apologize. I think that may have been my fault because I had a YouTube session opened. I was watching the previous arguments and I just shut it off. So now it seems fine. So.
Okay,
Okay.
that's what it was.
Well,
Phew.
we're learning together. So this is the matter 19P 1345. Diplomat property manager versus Daniel J. Wilson and another. We've read your briefs. Thank you very much. We're familiar with your arguments, so you need not recite the facts unless you feel that they're pertinent to your argument. We're going to try to keep things as normal as possible, given our remote platform here. And with that, Attorney Dion, perhaps you could begin by speaking to the status of the Thompson case in the SJC, if you know. I think that was argued on February the 13th. I want to say, I could be mistaken about that.
Exactly, Your Honor, yes. February 13th was the oral argument in Thompson. The court recently waived the 4-month limitation to render a decision, and we are still patiently waiting a decision in the Thompson case. We know they have a lot to do up there, so we're still waiting.
Okay. Well, with that, you have the floor, sir. Can we start the clock? Can we start the clock over, please? Thank you.
May it please the court, Attorney Todd Dion, on behalf of the appellants, Daniel and Angela Wilson, the Honorable Justices of the Massachusetts Appeals Court, good morning.
I apologize. Your panel is Justice Ditkoff and Justice Singh. I apologize. I'm Justice Desmond.
Thank you, Your Honor. As the court is aware, this is an appeal from an eviction case in which summary judgment was granted to the appellee. My clients, Daniel and Angela Wilson, challenged the validity of the foreclosure in which the appellee asserts possession based on some of the arguments presented in the Thompson versus J.P. Morgan Chase case. The reason why a stay was never asked for in this case was mostly due to timing issues, as well as a desire on both sides to have a higher court's opinion on this issue. The case ran parallel to Thompson timing-wise, and in case one of the matters settled or resolved, I believe both sides concurred in pressing forward with this matter. Now, with that being said, Thompson is still pending, but there are some issues I'd like to focus on, as they may not have been clearly or succinctly addressed in Thompson. The lower court's decision in this case consisted of a one-sentence, arguably a one-word handwritten opinion, which stated, as for the issue raised in Thompson, although I agree that paragraph 19 of the mortgage must be complied with strictly, I disagree that the notice of any cure rights under paragraph 19 as contained in the 209 CMR regulatory notice is deceptive or confusing. Now, in light of the standard of strict compliance that these notices are required to follow, in light of the inconsistency between the language of the notice and the language of the mortgage, and in light of the general and basic logistics of acceleration and foreclosure, I really don't see how anyone can say that the language in this notice, when compared to the mortgage, is not confusing unless they're not looking closer at the issues.
So leaving that aside for just a second, you're not suggesting that your client tried to take advantage of paragraph 19, are you?
No, I'm not, Your Honor, but prejudice is not required to be shown in a case like this when you're looking at strict compliance.
And and do you agree that paragraph 19 and paragraph 22, one speaks to the lender's obligations and one speaks to the borrower's rights?
Well, paragraph 22, both, Your Honor. So, I mean, paragraph 22 requires the notice to contain the information that's in paragraph 22, but it must be complied with strictly. So if there's any extra language that goes beyond paragraph 22, it must not conflict with one of the rights delineated in paragraph 22.
And so we're strictly talking about a 5-day difference in a deadline. Is that?
Well, there are a few reasons why I allege this notice is confusing. First of all, the language in question does not explain what the total past due amount means. And these words could mean something very different depending on whether or not the mortgage has been accelerated and whether or not the right to reinstate has expired. What's particularly concerning about this is the statute that controls the regulation under Chapter 244, Section 35A does not contain a requirement that the notice inform the homeowner that he or she has a right to pay only the arrearage amount any time prior to the foreclosure in the first place. If you look at 35A, letter C, it lists the information that must be in a 35A notice. And 35AC number 8 is the section of the statute that the regulatory language appears to be referring to. 35AC 8 only mandates that the notice inform the homeowner that she may redeem, in other words, pay the full accelerated amount prior to the foreclosure, because that's what redeem means. So to pay the full accelerated balance in full.
And in this case, that amount was what, a little under 100,000?
Well, no, the 100,000, Your Honor, was the arrearage amount, not the total amount. There's nothing in the statute 35A that says total amount. The closest thing is number 8 of Section C, which says it should be the redemption amount. So it appears that the notice is erroneously referring to the arrearage amount rather than the accelerated amount. For example, like Your Honor said, immediately below the language in question on page 29 of my appendix, the notice refers to the total past due amount as the arrearage amount rather than the redemption amount, which is inconsistent with the language of the statute in the first place. I'd like to note that during oral argument in the Thompson case, Justice Kafka asked whether or not this difference was just a matter of math and if a difference of a few cents would constitute a Pinty violation. But with all due respect to Justice Kafka, that question minimized the substantive difference between an accelerated mortgage and one that is not accelerated. Because first of all, the difference between an accelerated redemption amount and an arrearage amount would never just be a few cents in the first place, because the redemption amount includes the principal amount of the loan. Also, there's a huge substantive difference between an arrearage, cure, or reinstatement amount and an accelerated redemption amount, because the reinstatement amount reinstates the periodic payment terms of the mortgage, while a full accelerated redemption amount is immediately due and payable. Finally, one of the arguments that I made in the Thompson case as well is that I believe it's an impossibility to say that the homeowner can pay less than the accelerated amount any time before the foreclosure, because the mortgagee must foreclose on the full accelerated redemption amount anyway, rather than a partial arrearage amount. And in order to do that, the mortgagee must demand the full accelerated redemption amount without giving the homeowner an opportunity to pay less than the accelerated redemption amount. Otherwise, there's not a true, meaningful accelerated redemption demand. And that's presumably the reason why there's a limitation on the right to reinstate in the first place. So whether it's 5 days or 5 seconds before the foreclosure, at some point before that auction, there needs to be a true acceleration without giving the homeowner a right to pay less than the accelerated amount, because that's what the mortgagee is foreclosing on.
I watched you argue just about that for some time, so we'll find out the answer to that. But what's different between your case and Thompson is that in Thompson, as far as I can tell, the foreclosing bank also was the bank purchasing at foreclosure. And here you have a third party purchasing at foreclosure. Now, you say in your reply brief that maybe they weren't really a third party. I didn't see that raised below, but I also didn't see anything about this third party claim raised below. So what was raised below about this third party issue, if anything?
Your Honor, I believe that Diplomat Property Manager is an agent of Phase Servicing. They hired the same attorneys, and I'm challenging the validity of the foreclosure and the Diplomat Property Manager's claim for possession by trying to rebut that the foreclosure was conducted lawfully.
Right, where did you raise that below?
I raised as far as I raised that the Section 21 was not strictly complied with by stating that the
judge that Diplomat is not a third party from Wilmington Trust or the servicing company.
Yes. So I'm challenging Diplomat's claim for possession based on the fact that the foreclosure was not strictly complied with.
Yeah, I understand that, but one of the things that Diplomat says is because they're a third party arm's length purchaser for value, they have statutory protection from your claim. And you say that doesn't work because they're not really an arm's length purchaser. And I'm asking you, you said in your reply brief, where did you tell the Superior Court judge that?
The issue was never brought up at the lower court. It was never argued. It was never argued on both sides.
Right.
So if I may continue, the notice also fails to explain that the unequivocal, and it's an unequivocal right, the right to reinstate and cure the default expires 5 days before the sale. This is an important distinction, especially because the right to reinstate is unequivocal and it guarantees the homeowner recourse prior to 5 days before the sale, whereas within 5 days before the sale, there is no recourse under the mortgage contract because the language in the notice does not extend this unequivocal right. The notice simply states you can avoid foreclosure by paying the total past due amount. And that language does not ensure that the mortgagee has to accept less than the accelerated redemption amount within 5 days of the foreclosure. For example, page 30 of my appendix has a section, the section in the notice is entitled Partial Payments, where it states that FAE reserves the right to reject a partial payment of the total amount due without waiving its right to proceed with foreclosure. I note that this language was not included in the notice in Thompson, and if there is a distinction between this case, the notice in this case, and the notice in Thompson, even if Thompson is lost, this language shows that the notice in this case is confusing because the language on page 30 is contrary to the contention that you can still avoid foreclosure by paying the total past due amount. So at the same time, the language could mislead the homeowner into sitting on his or her right to reinstate and cure the default. Now, this is where the First Circuit found the language to be confusing and potentially deceptive under the standard of strict compliance in Pinty. The fundamental analogy to Pinty when compared to this case is in the same way the notice in Pinty could mislead the homeowner into waiting for a lawsuit for foreclosure rather than affirmatively bringing a court action. The additional language in the notice in this case could also mislead the homeowner into waiting on the right to reinstate and cure the default until after 5 days before the sale, when that unequivocal right does not exist anymore.
Do you dispute that Diplomat was required to include the Division of Banks language?
No. What I'm saying is they are required to include that language, but they're also required just not to do a cut and paste job and to also add some language that explains it more. Since they chose to draft a hybrid letter a paragraph 20, a letter that purports to comply with paragraph 22 and section 35A, in light of the fact that the paragraph 22 writes there's a standard of strict compliance in explaining those, that there should have been more of an explanation that there is.
I'm sorry, don't you assert that the division of bank language, looking nowhere beyond that, is manifestly confusing?
Well, yes, because first of all, it doesn't explain what total past due amount means. It's
So
not.
what difference does it make if they wrote it in a hybrid or if they wrote it in two separate letters? What difference does it make?
Well, the difference is even more so if they're drafting a hybrid letter, they're to adhere to a standard of strict compliance when we're talking about the paragraph 22 notices. So that's, but even still, the language is confusing because total past due amount is not explained. You can find it nowhere in the section 35A, and it's inconsistent with the terms of the mortgage, which say there's an expiration on the right to reinstate or cure the default. And I'm arguing that's an impossibility anyway, because in order to foreclose, they have to foreclose on the full accelerated amount anyway. So another inconsistency with paragraph 22 is the notice's failure to mention an expiration on the right to reinstate and cure the default is also a failure to strictly comply with paragraph 22C, which requires the notice to inform the homeowner of a specific date by which the default may be cured. All they give is the 90-day date, but the language in question is not an extension of the right to reinstate. And when looking at the language of 35A-C number 8, the total past due amount is supposed to be referring to the accelerated redemption amount anyway, rather than the partial reinstatement cure amount. So I'm arguing that it appears that the mortgagee is trying to make up for this mistake in referring to the total amount due as the partial arrearage amount after the fact by just, they're simplifying the issue and claiming that this language was intended to extend the right to reinstate and cure the default until any time before the foreclosure takes place. But when you look at the language of the controlling statute and the mortgage, it's not that simple, and it's not true.
And while many of the issues or some of the issues, the salient issues of this case and the Thompson case overlap, how can we not be well served by waiting to see what the SJC says in Thompson before deciding this matter?
I understand that, Your Honor. I explained that we agreed to go forward with this matter in case one of the matters settled. We felt as though we needed a higher court opinion on this issue. And I'm just, the example that I gave in this case, that the notice in this case even goes beyond Thompson, because on page 30 of the appendix, they reserve the right to foreclose even if a partial payment is made. That language is not in the notice in Thompson. So on one page, it says you can make a partial payment. And on the next page, it says, well, even if you do, we reserve the right to foreclose anyway. So they could very well, the bank could very well say, well, within 5 days of the foreclosure, your right to reinstate it's expired, and that language means total amount due, meaning the accelerated amount. It's plausible that that could happen, even though, of course, the bank would say otherwise, that they would accept an arrearage amount.
I see that your time, unless there's a question from one of the other panelists, I'm going to ask that same question to your sister, who I know says, notwithstanding Thompson, we'd like this court to decide this issue now. Isn't that what I read in your papers?
Yes, Your Honor, and good afternoon, and it may please the court. That's exactly our position. I don't deny that Thompson will certainly be instructive to this case, if not possibly outcome determinative. However, I do think that this case should continue on a parallel track for a couple of different reasons. First, there wasn't a request for stay made, so we have fully briefed this case. We are here at oral argument. I think it serves all of us to move forward. But I think perhaps more importantly, and this is really the heart of my argument, is that the law is settled on these issues before the court. The strict compliance standard is well settled. It's been a part of jurisprudence for over 100 years. It's codified in Chapter 183, Section 21 The SJC has further elucidated on it in Pinty and Mariquin and other recent cases, and we know what that standard requires. It requires a foreclosing mortgagee to comply strictly with the terms of the mortgage that relate to the power of sale and the statutes that do as well. And I don't think when applying that standard to this case, there's any dispute, or there should be any dispute, that we did strictly comply with those provisions, including paragraph 22.
That may be true, but how can it be prudent for this court to decide this issue when the very same argument has been made to the SJC on February the 13th? I mean, I just don't understand practically how that makes any sense.
And I understand, Your Honor, and I certainly, if a stay was imposed, I wouldn't completely disagree with it. I think that there are some fundamental differences between Thompson in this case, particularly that this is a post-foreclosure eviction case with a third-party purchaser. And because of that, for one, when we submitted the certified copy of the foreclosure deed and affidavit of sale, we did make a prima facie case for possession, and the burden did shift to the defendant. And so an argument that we did, or excuse me, that the foreclosing mortgagee did something potentially deceptive or misleading will not carry the day in a post-foreclosure eviction case in which we have a prima facie, we made a prima facie case.
Let me ask you the same thing I asked your brother, which is, where before the Superior Court did you raise your argument based on 244 section 35BF or based on an arm's length third-party purchaser?
So I don't think it was fairly disputed in the trial court that Diplomat is, or it was my understanding it was not disputed that Diplomat is a third-party purchaser solely on account of the fact that it is a different corporation from Wilmington Trust, but I did not make that explicit argument in my briefing, Your Honor.
I mean, if you didn't assert it, then there's no chance for the other side to dispute it.
That's fair to say, but what I would say is that I know my brother's argued waiver. I don't think it's waived. I think when we think of waiver and apply waiver, it's usually to legal claims for relief in theories. This is a response to an argument that I would think my brother was going to make. So it's essentially legal argument by counsel. I think we're free to kind of make new arguments on appeal. But what I would say about that issue, Your Honor, is there are two ways that the defendants could rebut our prima facie case. One is to show that we did not acquire title strictly according to the power of sale, and we don't believe that they've made that showing. The only other way is to show that there was some fundamental unfairness in the foreclosure. If the court accepts that Diplomat is a bona fide third-party purchaser, that argument's not available to defendants. But even if that argument is available to the defendants would necessarily have to show prejudice resulting from this allegedly deceptive division of banks language. And defendants have never attempted to show prejudice. They never argued that they had the means to cure the default or reinstate, which would have required over $100,000 payment. They never submitted evidence on that point. In fact, I think it's actually been conceded that there was no prejudice. So the fundamental unfairness piece, while I don't think it's a defense that's available to the defendants, I think that there's no scenario in which they can win on that point, Your Honor. I know my brother's arguing that this court and by extension, the SJC and Thompson apply a standard of law that simply does not exist under our current jurisprudence. The argument is that not only was Wilmington Trust required to strictly comply with paragraph 22, but that it was somehow required to use its imagination to discern that a hypothetical borrower would be potentially confused by the division of banks language and take active steps to remedy that potential deception. That is not the law that's applicable in the pre-foreclosure context. It's not a standard of care that's applicable in any arm's length commercial context. And I note in my brief that I contrast this with Chapter 93A. Even under our extremely protective Chapter 93A law, a plaintiff still has to show actual unfair and, or deceptive act, causation and injury. So what my brother is arguing is that this court, and by extension the SJC, should accept that a lender has a general duty of care to a borrower in the pre-foreclosure context that would require it to discern deception from division of banks language. And I think that's sometimes what gets overlooked here is that this was not language created by the lender. This was division of banks required language. The foreclosing mortgagee was not allowed to deviate from this language. If it deviated from this language, it would open itself up to an argument on that end. So this was required to be in the notice. And there's simply no duty, there's no standard of care that required the lender to discern potential prejudice and actively remedy it. And I just want to draw a distinction between, I know my brother mentions paragraph 22 quite often. I think paragraph 22 is simply irrelevant to this case. If you look at paragraph 22, it very plainly lays out the terms that a lender has to disclose to a borrower in the notice. And strict compliance only applies to those terms. And in Pinty,
one of those terms, counselor, is the notice shall further inform borrower of the right to reinstate after acceleration. I think you'd agree it means accurately inform the borrower.
yes, and I would say that the only provision that accurately has to be described is the provision you just mentioned, and that there's no requirement that the details of how to reinstate the loan have to be described.
But if the reality is that the right to reinstate after acceleration starts 5 days before foreclosure, and your notice says it doesn't, it starts the second the foreclosure sale starts, then haven't you inaccurately described the right to reinstate after acceleration?
Well, I don't agree that there's an irreconcilable conflict between the division of banks language and paragraph 19 of the mortgage.
Oh, I'm not saying there is, but assuming there is.
Mm-hmm. And assuming there is, and I think that's where the mortgage tells us exactly what happens. In paragraph 16 of the mortgage, it states, if there's any type of conflict between applicable law, which includes a state regulation, and a term of the mortgage, applicable law overrides the term of the mortgage. All other terms of the mortgage remain valid and enforceable, but that term is overridden. So if we assume that there is an irreconcilable conflict, then the mortgage tells us exactly what happens, and the borrower would get the benefit of those 5 days. And therefore, under that interpretation, our notice was literally accurate because it told the borrower that in this division of banks required language that it had up until the time of foreclosure to pay the past due amount and avoid foreclosure. So I think, I don't think that there is an irreconcilable conflict. If there is, then in that case, the mortgage, the form mortgage, and the mortgage in this case tells us what happens. And the notice is consistent with that. Finally, I just wanted to emphasize the difference between this case and Thompson, while understanding Justice Desmond's point, and certainly understanding that a stay would not be inappropriate in this case. I do want to emphasize that this is a post-foreclosure eviction case, and courts have been very clear. This is not in the nature of tri-title, although a defendant can put forth a defense that title was not acquired strictly according to the power of sale. The universe of claims that fall under that are very limited. And as I mentioned, I think paragraph 22 is not relevant. We strictly complied. Paragraph 19 includes no notice provision, so we necessarily could not have violated paragraph 19, even assuming there's a strict compliance standard. So what my brother is actually arguing is that the foreclosing mortgagee did something potentially deceptive and potentially unfair, and that is never going to be enough to rebut prima facie evidence in a post-foreclosure eviction case. If there are no further questions from the court, I'm happy to rest on my brief, and I thank the court for its time.
Well, thank you both. Don't be surprised if you do see order from this court that we stay the proceedings until we have the benefit of the SJC's view on the issues which do overlap, notwithstanding there may be separate issues apart from those raised in Thompson.
Certainly, Your Honor.
Thank you,
Thank
Your
you.
Honor.
Thank you.
Thank you.
So as we touched on earlier, Joseph, and I don't know if you were on the call earlier, Sabita, that it seemed to me.
We're still streaming.
Oh, okay.
Sorry about that.
And one matter has been continued until our next sitting on September the 16th. We stand adjourned.